Okay, well, in the interest of time, I'm going to start our session this morning. Good morning and welcome, everyone. Thank you for joining us for today's Fundamentals in Healthcare Law webinar focused on physicians and practices. As many of you know, this is our 11th of 12 webinars in our Fundamentals of Health Law series. Our final webinar is scheduled for Wednesday, August 17th. From 8:30 a.m. to 9:30 a.m., and it will focus on post-acute healthcare. A number of you have joined us for all 11 webinars, so thanks for being a part of this. And for those of you that are joining us for the first time, welcome. My name is Jason Castor. I'm the Chief Business Development Officer for Parsons, Behle, and Latimer, and I'd like to welcome you all to today's presentation and taking time out of your busy schedules to be with us this morning. Before I turn the time over to our presenters, I'd like to cover a few quick logistical items for today's webinar. First, our webinar is being recorded, and you will be provided a link via email to the recording to share with your colleagues and teams. This email will also include a copy of today's PowerPoint presentation, so I wanted to make sure you're aware that you'll get both of those. Second, we have a lot of time at the end for Q&A, so please use the chat feature to submit your questions throughout today's webinar, and we'll do our best to address your questions at the end of today's presentation. And lastly, it's important to note that today's presentation is considered a source of general information and is not intended and will not serve as a substitute for legal counsel on these issues. You should not act upon the information provided without consulting your legal counsel. All right, our housekeeping items aside, I'd like to provide you with just a brief overview of today's agenda. Our topics will include entity structures, sole proprietor, corporations, LLCs, and partnerships, differences between employees and independent contractors, and the importance of employee handbooks. We'll also cover professional contracts, management and service agreements, and leases, the important topic of leases. All right, our speakers today include John Stenquist. John is a commercial and real estate litigation attorney in our firm's Idaho Falls office. He has over 20 years of experience representing clients in all industries in a variety of financial, banking, corporate, construction, and real estate matters. Kelsey Kirkham is of counsel in the firm's Idaho Falls office. Her practice includes defending medical malpractice and licensure board disciplinary matters that involve physicians, hospitals, nurses, and other healthcare providers. And Brian Elwood, his practice focuses on representing dentists, group practices, dental support organizations, also known as DSOs, and other healthcare professionals with practice sales and acquisitions, support organization implementation, financing, and other corporate and transactional matters in the healthcare space. So our panelists, thank you all for being with us this morning. To get us started, I'm now going to turn the time over to John Stenquist to kick off today's webinar. John, I'll turn it to you.
Thank you, Jason. Good morning, everyone. As Jason mentioned, I'm a litigation attorney in the commercial area. I also do a lot of transactional work, and I have in my career set up a lot of corporations and help clients navigate the issues relating to business formation. As you know, a sole proprietorship is fundamentally a personal business where all of your personal assets are at risk. It's typically for startups where funds are limited and you have one bank account and you're just trying to get started. Once you get rolling, however, if you haven't incorporated with some formal entity, I would recommend you do that. And when my clients come to me and ask me how to best protect their assets and develop an asset protection strategy, I always tell them that the first line of defense in your asset protection plan as either a sole proprietor or as a business owner that is formalized is to get a good insurance policy. Read your policy. Look at getting an umbrella policy on top of it. By reviewing the policies, and you will see that there are exceptions to these policies. Typically, when you get coverage, you'll be presented with a very long and hard to read document. Most people don't read their insurance policies. They rely on the advice of their insurance brokers. I would suggest, however, that you take the time to open your policy, look at what the exceptions are, see if there are additional endorsements that you can get in your policy that fit your business needs. Obviously, that takes some time and it may require some additional professional help, but in all of our litigation that we look at, the first thing we try to do is see whether or not there's coverage available to cover attorney's fees in case of a claim and to ultimately cover any damages. Um, I've found that most people don't understand their policies and, in fact, get surprised sometimes when they discover there is no coverage. I'm involved in a litigation right now where two directors have been sued for actions while they were directors. And even though they have a D&O insurance policy that would normally cover them, there is an exception in the policy that does not cover them for claims brought by the company itself. They had recused themselves in a transaction. They had, and the company ultimately decided they didn't like how that transaction turned out, and they sued these directors. Well, there's no insurance coverage for them. It's a specific exception listed in the policy. So I would suggest that um, you look at your insurance policies, understand what's there, and see if you can get additional coverage for your particular risks. Having a good insurance policy also helps you in litigation, not just because insurance is typically required to pay for your defense costs, but it really helps in settlement. If there's an event where you have some exposure that exceeds your policy amount, oftentimes a reasonable insurance policy will get the case settled because attorneys know it's difficult to uh, take a claim all the way through trial in hopes of getting an excess verdict, an amount above the insurance policy, and then collecting that excess verdict from the insured. So it really helps, even though the claim might be larger than your coverage, the fact that you have a policy in place that is reasonable to the claims, although it doesn't cover everything, it really does help get these cases settled prior to that excess claim. And so it's always good to have a good, solid insurance policy in place, and I would suggest that you do that. So, although sole proprietors are common, sole proprietorships are common, I would suggest that you move away from them. Moving on to partnership, to general partnership. Partnerships are essentially two sole proprietorships working together. And that's kind of the worst way to do things. Partnerships, general partnerships don't provide any liability protection whatsoever. Um, but what they do is they create exposure for the actions of both partners. So one partner will bind the other to agreements, one partner will expose the other to liability. And unfortunately, partnerships are easy to create. In fact, there's a whole body of law that talks about accidental partnerships. Accidental partnerships occur when two people start talking about a business. Maybe they start acting in furtherance of that business to try to get it off the ground or working together. There's nothing in writing. And there's a fundamental misunderstanding of what is happening. Maybe one partner thinks that they are the owner and the other partner uh, is an employee, whereas the supposed employee thinks they're an owner. A dispute arises, there's nothing in writing, there's a lot of he said, she said involved, and vague emails. And now all of a sudden we have a dispute that's very costly because a partnership is created by accident. And like a marriage, partnerships are easy to get into. Business relationships are easy to get into, but they're difficult to get out of. So my advice is uh, go back and look at the agreements that you have in place. If there are multiple people involved in ownership, and look at how the partnership difficulties are resolved. Where I see problems, first, where there's a deadlock. If there's an equal number of owners or partners, there is a potential for a deadlock in how to operate the business. how are those deadlocks broken? I would look at your partnership agreement, your operating agreement, or other corporate documents to understand how do we break a deadlock. Um, I would also look at the agreements, or when forming one, have a lot of provisions on how to get out of the partnership. For example, what are our prenuptial terms on how do we dissolve it? How do we buy each other out? What if someone wants to retire, wins the lottery, and no longer wants to work? Can we afford to split the business in half on day one, or are there going to be some buyout provisions? And so that's really important is to understand what the agreement is, but not just what the agreement is to operate a happy, healthy business, but what is the agreement when we have deadlocks and we need to remove or leave a business. Um, Moving on to LLCs, limited liability partnerships, and limited partnerships. These are these are entities that we suggest that provide a single layer of taxation. So the entity itself is not taxed. They file an information return and then submit K-1s to the owners. These documents are formalized, and but they don't have a lot of the same requirements of a corporation, which we'll talk about in a minute. But we suggest typically that you form a limited liability company or talk to your accountant as to whether or not another entity might be better for tax purposes. Those those entities, if you respect the corporate form, have separate bank accounts, hold meetings, keep your registrations current, will protect your personal assets. They are a little bit more work because you do have to follow the governance formalities, but you will want to have um, your business incorporated somehow. Um, it helps on dissolution, it helps when there's a buyout, and it helps when there are disputes. And finally, as far as corporations go, I'm running out of my allocated time, but corporations are for moving on, Jason, to the next slide. There are corporations where they can be taxed as a partnership, like an S corp. You make what's called an S election. S corps are limited in how many and what types of owners you can have, but typically corporations you'll find require regular meetings. They require elections of directors and appointment of officers. Corporations are typically formed for more complex organizations that are going to have regular meetings anyway, that need a really good structure, that have professional management. They do have benefits upon, you can go, it's easier to go public, it's easier to sell to investors, it's easier to raise money and those kinds of things. So as your business grows, you might consider a corporation as your corporate form, and I certainly would advise you to talk to your attorneys and your accountants on whether or not that'll work for you. And with that, I will turn the time over to Kelsey Kirkham to talk about independent contractors and employees.
Thanks, John. My name is Kelsey Kirkham. I focus my practice largely in employment law and medical malpractice defense and defending licensure complaints. So this is a great intersection of those two worlds. An issue that we often see and that's often relevant in employment law and in defending complaints with licensure is whether whether a person is an employee or an independent contractor. And there's several reasons why that matters. So just some general kind of questions to spark that analysis is, what does the worker think? What does the company think? What does the public think? So just because a worker or a company thinks that somebody might be an independent contractor versus an employee, that might not be enough, as we'll get into, based upon it's a legal relationship and it's based upon many factors. But regardless of whether one is an employee or an independent contractor, that can have an impact based upon what the public thinks. If a person is an independent contractor, but they appear to be an employee of a company, then that creates risk if there's a claim that's brought against the healthcare company for any negligent acts of the individual. So even if they are an independent contractor, but there's a apparent authority relationship based upon the public's perception, then that can impact how the independent contractor is ultimately treated. Why does it matter? Who cares? There's so many benefits that employees are entitled to, and that the company can offer certain benefits to employees, but that independent contractors are not entitled to. So it's a cost-saving mechanism that companies use to outsource and hire independent contractors as opposed to employees, but it's important that that relationship is accurately classified. Otherwise, it can create liability issues, and there can be a risk of misclassification and bring claims against the company for that misclassification. Who is an independent contractor? There's a few different tests that can truly examine that, and we won't get into that today, but generally, an independent contractor is one who offers a particular service to the public or an industry for a fee, but they're not economically dependent on any single company. They can provide services for 2 different hospitals, 3 different hospitals, and a clinic, whatever the case may be. They are not employees. They're not subject to a certain amount of hours to work for the particular company. Like I said, this is a legal category, and even if an employer and an employee, or an employer and an independent contractor decide that they want to do one particular relationship, that decision in and of itself isn't always going to carry the day. An independent contractor typically will charge a fee for their services, and their engagement with the company is limited to a particular service or task, and for generally a specific term. And the independent contractor themselves, as opposed to the company, retains control over the method and the manner for their work that they're doing. They retain independence in their economy, and, like I said, free to offer services to other companies. And independent contractors are responsible for paying their own income taxes, Social Security, Medicare taxes, workers' compensation, and other similar taxes. And independent contractors are not covered by most federal, state, or local employment protection laws, such as the ADA and other discrimination. So that's another benefit for companies to want to use independent contractors. An independent contractor does not receive company-sponsored benefits. No paid vacation, no health insurance, no retirement, and they do not perform the same work as company employees. The work has to be different as to the scope of the work, and the independent contractor should not have indicia that would give the perception, this is the public perception, that they are an employee of the company. So we don't want independent contractors wearing the company name on their shirts or carrying around business cards. That confuses the relationship. An employee, however, is subject to significant oversight and control by the company. And in dealing with misclassification allegations and complaints, that level of control is a heavy factor that's considered by the courts. So it factors largely on what wages are being paid, and how is each employee receiving benefits, benefits from workers' compensation insurance. The employee is employed for a prolonged period of time and works regularly scheduled hours and performs whatever task the company requires. Typically, with employees, we have job descriptions that would tell them what their scope of employment is, And independent contractors wouldn't have a job description, but they would have an independent contractor agreement that would otherwise specify the terms of their engagement. For employees, the company pays their income, Social Security, Medicare taxes through the employer, and the employer is obligated to withhold that from their wages. But the employer would not withhold those for someone who is an independent contractor. Employees would be economically dependent on the employer. It's not to say employees can't also have more than one job, but they rely on their employer more for their source of income. And employees are protected by federal, state, and local employment laws. I see this most often in the typical classifications in hospitals, and it becomes a clear distinction in how litigation can pursue. So independent contracts generally are going to be with the physicians and other providers that have an office outside of the hospital, but they come and have privileges to perform particular procedures within the hospital. Beyond that, employees are going to be nursing staff, administrative staff, and most other hospital-specific task-oriented employees. So when a complaint is filed against a hospital, for example, the hospital may be liable for its nursing staff, administrative staff, etc., but for its physicians who are independent contractors, as long as it's all properly documented and there's no other public perception, then the hospital could not be liable for acts of the physician. And the hospital forms that patients sign, particularly like a conditions of admission form, that should include just a standard provision that indicates that providers are not employees of the hospital and they are independent contractors and have the right to control and make decisions about the care that they provide. And that really helps to put notice on the public for that relationship. So high level and very generalized distinction for that legal liability. Employees are going to be considered agents of the company, and the company can be vicariously liable for the acts of its agents, which are performed within the scope of their employment. There are exceptions to that, but that's general and broad. On the other hand, independent contractors are generally not considered agents of a company, and the company is generally not liable for acts of independent contractors. Again, there are exceptions and other factors that go into that, but that's high-level generalized distinction on legal liability. So best practices: use an independent contractor agreement to establish the terms with each and every independent contractor that you have, and avoid using independent contractors to perform work that is otherwise integral to the business. Nurses are constantly checking on patients and have, every hour, every 2 hours, whatever the particular requirement may be. But physicians are coming in and doing rounds and checking on patients and going back to their office. Require independent contractors to complete a Form W-9 and request a taxpayer identification number, whereas employees would complete a W-4 and receive a W-2. And another really important aspect of that is to keep independent contractor agreements and other files related completely separate from employee files. And it's even thinking of it like employee files go with human resources, independent contractor agreements go with administration. Pay contractors by the project or by a flat rate and on regular intervals, but not by the hour, not by the week, not by the month. All right, I'm going to turn it over to Brian for professional contracts.
Thanks, Kelsey. Good morning, everyone. As Jason mentioned, my name is Brian Elwood. My practice is primarily focused on transactional work related to the healthcare industry. And so whether it's medical, dental, chiropractic, formation of those entities, starting, helping them start their business to selling their business, and then a variety of regulatory matters I work with as well. So in addition to the physician employment agreements and independent contractor agreements Kelsey discussed, there are a couple of other key contracts or agreements, relationships we see in the healthcare space that I think are important to note. And maybe I want to give a little background on why these contracts are important or why they're necessary. And it's primarily due to, one of the key factors is the corporate practice of medicine. And as John discussed in his presentation on entity types, we've seen an evolution over the last 150 years on, from sole proprietorships to corporations to limited liability companies and similar types of entities. And for a long time, as that developed, there was a pushback against allowing doctors to form corporations to provide healthcare services, for the fear that the doctors would hide behind the corporate shield of the corporation when it came to medical malpractice issues. And over time, that's alleviated. Doctors can obviously incorporate and have corporations, professional corporations, limited liability companies to form their practice to provide healthcare services. Well, then out of that also came the concern that corporations, non-doctors, would own these corporations. And then the concern came with, undue influence of doctors' clinical judgment. And so what we've seen is the development of the corporate practice of medicine doctrine, where we really get a prohibition on, in most states, and again, this is a state-by-state analysis, but the corporate practice of medicine prohibits non-doctors from employing doctors to provide medical services. And so we also see the situation where, okay, so then we have to have doctors own their own corporations to employ other doctors or other clinical providers in providing those services. And that's meant to protect the patient, to make sure that the bottom line, so to speak, is not driving the decisions and advice being given. So the doctor's medical independence can be maintained. And so out of that, we also see some prohibitions on fee splitting. So doctors can't split fees with others, with non-doctors. Same type of protection intended there. So with those two things in mind, we have a few contracts here where we look at the corporate practice of medicine is the overarching driving force here behind those. And one of those is what we call a professional services agreement. And this contract is typically entered into between a healthcare practice, a doctor's office, so to speak, and a hospital or other healthcare entity, where the doctor or group of doctors agree to provide professional services, or their practice does, in return for a fee. And those fees can be rather straightforward or complex, but the doctors maintain their employment with their practice and essentially agree to provide contractually these services to, like, a hospital. And you can even go so far as in return, the hospital or healthcare entity can provide, in return, in addition to a fee, the practice, the doctor group, with administrative support, such as they'll help them do their billing or help with their cash management or collections, even so far as employ the doctors, the dental or the doctor's office staff or dental office staff, even as employees of the healthcare entity to facilitate benefits and payroll and things like that. Now, these can be really complex, or there can be their underlying laws that make this a rather complex arrangement between Stark, anti-kickback, IRS regulations, and also state professional employment organization compliance issues. This is each of these has their own unique issues, but the PEO, Professional Employment Organization, state regulations layer in another rather complex level of analysis and compliance that need to be attentive to. So we see these done all the time, but there's just a layer of regulation complexity here that needs to be remembered and focused on. The next contract is the physician recruitment agreements. When we have a need, and these are typically used when there's a need for a healthcare service, a specialty service, doctor, medical services in a particular area that's lacking that service. And these agreements are permitted under Stark and anti-kickback statutes, but there's requirements that have to be met. One, there needs to be a documented need for that healthcare service to be provided. And then once that's been documented and there's established need for that service, a hospital can go out and look to recruit a doctor to come into the area to relocate their practice into the area to provide those particular services, usually for a certain period of time, usually under some form of a guaranteed minimum salary or some kind of financial arrangement with the doctor. And usually that guarantee is in the form of a loan that's forgiven if the doctor satisfies their obligation of staying, relocating and staying in the area for a particular period of time. And also, if they don't, if they move and then leave before that agreed upon time period, they can have to repay all or part of that guarantee portion of that arrangement. So we often think of anti-kickback statutes and Stark laws as restrictive, which they're there for a reason. But there's also a good reason. They also facilitate things like this. That there's a need out there. That there's exceptions to those rules to permit incentivizing healthcare in areas that are lacking in it. And the third agreement I wanted to visit about is the management service agreements. And we see these have developed for many, many decades. And really, we've seen an evolution of these agreements, starting first with medical MD services. In the last 20 years, the proliferation of these types of agreements in the dental industry is becoming is rapidly accelerating. And then we're also starting to see these types of agreements in other healthcare areas, chiropractic, for example, where these agreements essentially are between a healthcare practice, medical office, dental office, and so forth, with a non-clinical entity to come in and provide that medical healthcare practice with non-clinical administrative services in return for a fee. And these can be as simple as providing some form of accounting function to a very fulsome arrangement where they provide essentially all back office support for the medical practice. And so they really take a broad swath on what can be provided. But again, these arise out of the corporate practice of medicine and fee splitting prohibitions. Again, a doctor or a non-doctor cannot own a medical office in most states, not all, but most states. And out of that prohibition came but there's a business need that can be filled there by having someone that's can create efficiencies and economies of scale in the back office administrative functions. We have the opportunity to have these management services agreements, and they're all really predicated on the clinical versus non-clinical service functions. The clinical needs to be provided by the practice. The non-clinical can be provided by this third-party non-physician group, and the management company can be owned by doctors or non-doctors or a combination. And so we need to keep in mind when we're looking at these types of agreements that what constitutes the practice of medicine varies from state to state. But all medical decisions as defined by that state's laws need to be left to the doctors. And so in some states, the practice of medicine can include functions that on their surface would appear to be administrative in nature and not clinical, but which in fact are clinical. And a couple examples of that are in Texas, for example. There's some in various other states as well. The definition of the practice of medicine or dentistry or whatever it might be in that state really reaches into the management of an office, of a medical office, where in Utah, for example, very much hands-on, patient-focused, and not so much the management of the office, which constitutes or does not constitute the practice of medicine. So you always have to keep those things in mind. And These types of arrangements can also include where the management company provides or supplies equipment, chairs, tables, computers, X-ray machines, diagnostic equipment that are used by the doctors in their providing medical services. So they can be very broad. That even the management company can provide non-clinical employees, staff, non-clinical staff to support the practice, and so they can be very broad in their approach. And the types of services we typically see them provide can be very broad, a very broad range of services. They include, I think, fundamentally accounting, bookkeeping, budgeting, billing, and collecting. A big one we see is accounts payable and cash management can be involved or provided. And as the group size grows, we'll see marketing, human resources, and then other aspects such as supply and inventory management, IT, technology, training, call center services. Some states have regulatory environment where they require registration of these types of arrangements. Texas is the primary one. North Carolina, at least in the dental space for North Carolina, will require pre-approval. So you need to be mindful of those state laws when it comes to these types of contracts, because some states do regulate these and require them to either be the parties to register with the state or to actually get pre-approval for the relationship. Now that's pretty limited, but that does occur at times. So just what I thought was helpful to touch on those three types of contracts that we see in the healthcare space as they tie into regulatory issues. I'd like to turn some time back over to Kelsey to talk about employment handbooks.
Thanks, Brian. Just in a little bit follow up from my previous discussion with you all. As I mentioned, independent contractors are going to have independent contractor agreements. Employees typically don't have employment agreements, and that is because, especially in Idaho and most states, your employment is at will. So employment handbooks are encouraged to have, and it sets forth all the general terms relating to employment. And it could include things such about benefits, time off, what constitutes a work week, and most importantly, though, it should include equal opportunity provisions, anti-harassment, anti-retaliation discussion, drug and alcohol testing, those types of things that all employees would be subject to regardless of their particular job titles. Employees should sign an acknowledgement of receipt and understanding of the handbook, and that acknowledgement should be kept with the personnel file for each employee. This helps to protect the company or the healthcare entity later if there's any challenges to conduct that's otherwise described within the employee handbook. And it also helps to create challenges if an employee were to otherwise try to argue that their employment was for a specific, they had an employment contract. I strongly advise in any employment handbook to include a very conspicuous disclaimer that employment is at will. And unless there's any other employment contract that specifies the scope and work in terms of their employment, that employee handbook is going to govern. And to have that classification of employment at will boldly stated within an employee handbook is going to be a really important factor if that type of relationship is ever challenged. In addition to the disclaimer that the acknowledgement that they received and understand the handbook, it should include the disclaimer that it's not a contract. And the acknowledgement should state that the employer also has the right to modify or delete policies with or without notice. In a contract setting with independent contractors or any other sort of employment contract, an employer wouldn't have that same right to modify or delete provisions of the agreement, but because employment is at will, that gives the company a lot more liberty to modify or add or delete policies within the handbook without giving notice or breaking any sort of contract that might otherwise exist. Independent contractors would not be bound by the employment handbook. So if there's any provisions within an employment handbook that you would want an independent contractor to be bound by, such as anti-harassment, anti-retaliation, those sort of things, then you would want to make sure to include those specific references within a specific independent contractor agreement. Keeping the classification separate in company documents, as we talked, is very important for maintaining that you will be upheld with any challenge to whether that classification was employment or otherwise. And a lot of this with employment handbooks, you're creating this document at the outset, and so it's kind of a mindset of what would you want to have explicitly stated and signed by the employee if the employee were to challenge that relationship in 5 years. And so it's foresight rather than hindsight on making sure that you're set up in the best way to protect you for any sort of claim later to by the employee. And then, as we discussed, the overlap of responsibilities and integrating independent contractors into a employee handbook would create risk of misclassification, and misclassification creates a risk for litigation, which creates a risk for damages to be paid out by the company to otherwise rectify that misclassification. All right, back to John to wrap up with lease considerations.
Thanks, Kelsey. I appreciate that. The lease considerations that we have, typically, if you are entering into a lease with a third party, they hand you a standard lease. For a physician, obviously, we review the physician will typically review the price and the term and those general issues. But we have found that these leases need to be a little bit more custom than just what is handed to you by a landlord. You need to look at issues that might raise HIPAA concerns, such as landlord access to property after hours, emergency access, whether or not the physicians or a physician's agent will be there to accompany a landlord. You'll need to look at the lease for medical specific issues, waste disposal, hazardous materials, substances. Obviously, if you're keeping prescriptions or drugs on the property, how you're going to deal with that. Obviously, there's rules and regulations, and those issues should be incorporated into the lease. Oftentimes, physicians own the properties that they're leasing. They are essentially, they bought the building and then they're running their practice. It's a good idea to have the entity that owns the building separate from the practice. And what we often see is the accountants at the end of the year will make some kind of financial adjustment and allocate some of the expenses to the other entity so that a reasonable amount of rent is deducted from the physician's income. However, oftentimes those relationships are not documented with a written lease, and we suggest that you do have a lease in place. That will help on dissolution. It helps respect the corporate form if someone tries to pierce the corporate veil. And so we do recommend, regardless of what the ownership is, that there is a written lease in place, even if it's a single physician that owns both the practice and the building. And talk to your accountant about the amounts and what's reasonable, and make sure that the written lease complies with what the accountant is doing on the back end in those deductions. Another thing that we often see is that a physician group will own a building. They'll have a good operating agreement on the business side, but then they don't take care of the separation issues in the lease. And so what we've, like my prior comments about getting provisions to address deadlocks and breakups and dissolution, you need to have that consistent with the lease. Oftentimes there's a lender involved, and you need to make sure that the loan documents, the guarantees, the lease, and the corporate formation documents all work together so that if there is a separation or a buyout, those issues will be resolved. In fact, oftentimes the building component of a business is meant to be a retirement or profit center for that practice. So as you add physicians or other providers into the business, you'll want to make sure that there are provisions in the lease that allow for separate ownership and the addition of individuals into this group so that those issues will essentially be coordinated in situations where a lease needs to be extended over a period of time, that the tenant or the physician practice has the control and the ability to extend those lease provisions in a clear way so that there aren't issues that arise with the new partners. It's often a succession planning issue where you have the practice is going well, but then what do we do about the real estate? And remember, Idaho is a community property state, and so the spouse will typically own half of the shares of the entity, half of the rights to the building. And in that case, has the physician had the spouse sign off on the dissolution plans? Do we have a system in place if one of the physicians in the practice group happens to get divorced? What are the mandatory issues that the spouses need to comply with so that you can address those issues both on the real estate side and on the corporate side? And you should probably have those provisions in your corporate documents, in your real estate documents, so that if there is a divorce, everybody knows what's going to happen. It's a difficult conversation to have with everyone, but having a spouse sign off on important provisions of the lease and the corporate documents will protect the ongoing business concern that we want to preserve and not create a difficult situation if one of the practice group owners happens to have a divorce. With that, I'll turn the remaining time over to Jason for some Q&A.
John, thank you very much. And I'd also like to extend a big thanks to Kelsey and to Brian for your involvement and the time and energy that you took into preparing for today's presentation. Great content, great stuff. We hope all of you found this to be of value. Hopefully there's some good takeaways that Brian, John, and Kelsey shared with each of you today that you can take back to your practices and after thoughtful consideration, perhaps implement some of these these issues. I have not seen any questions come in through the chat feature. So, before we wrap up here, let me just go back to our panel real quickly. And Brian, let me start with you. Do you have any final takeaways for our attendees today that you'd like to share?
I think the only thing I would say would be just to be mindful of the corporate practice of medicine doctrine when it comes to contracts. There are always issues there to be at least considerate of in who owns what, whether they're a doctor or not, and making sure there's nothing that's overstepping that relationship, and that clinical decisions always need to be with the doctor. We see that often blurred, oftentimes, but that's important to remember.
Great, thanks, Brian. John, I'll ask you the same questions. From your perspective, any final takeaways that you'd like to leave our audience with?
Well, I think most of our audience will have corporate documents in place. They'll have leases in place. They'll have insurance policies in place. But it's always a good idea, maybe on an annual basis or semi-annual basis, go in and review everything. Situations change in our professional lives, and the documents are the last to be updated. And in my experience through the litigation, people aren't reviewing these documents until there's a problem. And what we find is practices kind of morph, things change, the documents aren't updated, then there's a dispute. And you say, well, what governs the dispute? Well, we've got to go back to the corporate documents and look, and lo and behold, they're antiquated and they don't address what we're actually doing today. So it's a good practice for practice administrators, for the physicians, to sit down, review the policies, review the corporate documents, review the leases, and make sure that the documents are following the behaviors of the practice.
Great suggestion, John. Thank you very much. And Kelsey, last but certainly not least, any final thoughts on key employment, independent contractor, handbook issues that you'd like to provide our audience with?
Thanks, Jason. I think just kind of piggybacking off of what John just indicated, a last thought that I would add is though employers can have employee handbooks and they are not required to, they can update policies, modify, delete things within the handbook without giving employees notice, to make sure that that notice on the employee is not outdated. It is a regular, it's a good practice to engage in regular review of the acknowledgments of receipt of the employee handbook and have employees sign a new acknowledgement every year or a couple years if there have been changes made to the employee handbook. And I would also add that the classification between independent contractor and employees can become kind of muddy. And so if there's ever additional questions that anybody would have to help analyze that distinction to make sure that they're in compliance, I'm more than happy to help give more advice on the particular tests.
Great. Thank you very much, Kelsey. John, I thank you again for your time today. Brian, I thank you as well. To all of our participants, thank you for being with us for today's webinar. By way of reminder, you will receive a copy of today's PowerPoint presentation along with a link to the recording. And finally, our final webinar of our Fundamentals in Healthcare Law webinar series is scheduled for Wednesday, August 17th from 8:30 to 9:30. This presentation is going to focus on post-acute healthcare. Keep your eyes peeled. You will receive an invitation by way of email from us within the next couple of days with more details, with registration links, etc. And again, big thanks to our panelists, to all of you for participating today, and we look forward to seeing you on Wednesday, August 17th. Thank you very much.
Thank you.
Thank you.